I seek your lordship indulgence in making a mention in respect of item number 11, hearing, item number 11.
Yes.
This morning, I have been furnished several documents pertaining to this case by the learned and listener AG. So I would like, I need some time to go through and discuss with my clients. If 2 weeks time will be granted.
What documents have been given to you?
Recruitment rules and other documents, I haven't go through properly. There are
Okay.
3-4 documents.
Mr. Victor L. Ralte, Learned Counsel, for the petitioner submits that he needs to obtain further instructions from his clients and therefore prays that the matter be adjourned and be listed again after
2 weeks, my
2
lord.
weeks.
The-
The state prayer is not objected to by the other side. Stop in view of above. Matter stands adjourned for 2 weeks.
I'm obliged.
My Lord, I also would like to seek your lordship indulgence in making mention of item number 8, my lord. I have taken the consent of the counsel for the appellant, my lord. Let the matter come up after vacation, my lord.
What is this matter?
This is regarding Meg appeal, Lordship.
I know it's Mac appeal. What is the story behind it? Because I've seen a lot of adjournments now and then.
Yes, Lordship.
Why it's been adjourned like that?
Lordship, this was died while he was boiling the bitumen, Lordship. He was working
It's a
under
case
the
of
BRT.
death, not injury.
Case of death.
Case of
Yes,
death.
Lordship, yes.
How much has been awarded?
No award, Lordship. It was
Dismissal,
dismissed.
my lord.
Oh, it was dismissed.
Yes,
Dismissed
Lordship.
by the tribunal, my lord.
So against that you've come.
My lord.
Okay.
So that can be fixed also in the first week after vacation, my lord. I can be ready there.
When do you want it?
Anytime.
15th?
Yes, Lordship, no problem. 15.
14 also, my lord.
Ah,
15th, I have one fixed item, my lord. On 15, my lord.
Only one.
Only one.
But this will take a long time or what?
My lord, no problem there on the 15 also.
Okay, as paid for by the parties. List the matter again on 15th of October
October,
2020 for hearing.
it's a blind, Lordship.
Yes.
Opus.
May I please? Lordship, I'm
Yes.
praying for listing of a unlisted matter, Lordship.
What unlisted matter?
NT-bail, Lordship.
Sorry?
NT-bail application, Lordship. We
Anti-bail.
have filed yesterday and it got registered already, Lordship. We have from Guwahati, Lordship.
You
Kindly
have already filed?
file and register also.
Okay.
May I seek your lordship indulgence in mentioning item number 10?
Yes.
Lordship, this matter has been taken up by my senior Mary and she cannot attend the court today due to some personal difficulties. Lordship, this matter may be listed after vacation.
Who, Miss Mary?
Yes, Mary
Lalram
Lalram
Hetty.
Hetty, yes.
She'll be conducting the case.
Yes, yes.
But Mr. Joseph's name is also there.
Yes, sir, Miss Mary is taking this matter.
Okay. Your good name?
F. Lazarzovi.
Miss F. Lal Zarzovi, Learned Counsel, submits that the matter is being handled by Miss Mary Lalram Hetty, Learned Counsel, for the petitioners, and since she has some personal difficulties, the matter may be posted again after the ensuing puja vacation. You are there on the side.
My lord, I'm on behalf of my colleague, Mr. R. Munsian, who is
Any
the-
objection?
No objection, my lord.
The said prayer is not objected to by the Learned Counsel for the opposite party. In view of above, list the matter again after the ensuing puja vacation on a date to be fixed by the registry. Yes.
Obliged.
Your Lordship, I would like to mention item number 9. As the main counsel, Mr. Leram Sangangaka is unavailable due to personal issues. And if the court insists, may this matter be listed after ensuing holidays and fixed on the 16th of this month.
16 will not have. It's Wednesday, so we can have it on 17th if you want.
If possible.
Any objection?
No, my lord.
Okay, as prayed for on behalf of Mr. Lalram Sangaka, Learned Counsel for the appellant and not objected to by the other side. List this matter. Again on 17th of October 2024 for hearing.
Obliged.
All right.
For motion, item number 1.
But please, Your Worship, in this matter, I have received the affidavit filed by the state. If I may be kindly granted about a week's time to file a reply.
Item 1.
Item 1. Your Worship.
It's listed for motion.
Your Worship, but notice of motion was issued.
Okay, it is submitted at the bar. The matter has been wrongly listed for motion. Since notice of motion was already issued on
It was first listed on 9th of September, Your Worship.
that particular sentence is not there.
Sorry. Your Worship.
Cancel that line. Please rewrite. Right, Mr. A.R. Malhotra, learned counsel for the petitioner, submits that he has received a copy of the affidavit in opposition filed by the which respondent?
Respond 1 to 3.
Respondent numbers 1, 2, and 3, and therefore he may be given how much time?
Your Worship, but 2 weeks time.
2 weeks time to file a reply to the same. Stop. Next para. It appears that notice of motion has not been issued, and accordingly, let notice of motion be issued, returnable by 2 weeks. Since Ms. Caroline K. Lung Oipui, learned government advocate, appears for the. How many respondents are there?
4.
Respondent numbers 1, 2, and 3. No formal notice is required. Stop. In fact, the respondent numbers 1, 2, and 3 have already filed their counter affidavit. Then what about 4? What to do?
Steps will be up.
Petitioner to take steps for service of notice upon respondent number 4 by registered post with AD due within 4 days. Today is the last day, is it?
Yes.
Can you take it by today itself?
Within, it's a bit difficult.
But things will be closed, isn't it?
Within 10 days, just after the holidays, we'll take steps.
Okay, within 10 days.
But the interim order may kindly continue, Your Worship. 9/9/2024.
When do we list the matter again?
After 2 weeks, Your Worship, is today is 4th. 18th.
List the matter again on 18th of October 2024. Till then, the interim order passed earlier shall continue.
I'm obliged.
Supplementary list for orders, item number 12.
Please, Your Lordship. There is a slight delay of 14 days in filing the connected review petition. In fact, this is coming up for the first time, Madam.
Notice will have to go.
Yes, Your Lordship.
But Mr. Lal Fakoma, learned counsel for the applicant, who submits that by filing this application, the applicant seeks condonation of 14 days delay in filing the connected review petition. Stop issue notice, returnable by 3 weeks. Petitioner, applicant to take steps for service of notice within 10 days. Can you take it today?
Yes, Your Lordship. I'll make it.
Within the course of the day. List the matter again after 3 weeks.
Deeply obliged.
The respondent may file objection in the meantime, if so advised.
Deeply obliged.
Item number 13.
In item number 13, I have received the CDR of Zo Sang Kim and Cook Khankwala.
Okay. So what does it say?
My lord, there is a, they have contacted each other on 8/11/2022.
Okay. Can you mark it?
I have marked it, yes.
Only on one day? How do you say they are contacted each other? Both the phone numbers are there.
Numbers are there, incoming and outgoing,
Okay.
the same.
And how many phone calls?
3.
3 phone calls.
Yes,
Okay. The yellow flag is the one.
yes.
Can you point out which number is whose?
I have written on top, my lord, in the other one. Then now phone numbers.
And who is Kup Khankwal?
Accused.
The main accused.
He's the main accused. He's also in custody.
Yes, my lord, I think he's still in custody.
And
From the phone call reports, this So Sang Kim is the present applicant was arrested.
now, can you just tell me who has called who? And it is the accused, the second accused calling to the present applicant, or the applicant calling
My lord, it's a incoming call and outgoing call.
in, out? Okay. It means received.
Yes.
And who's the caller in the next column?
Page 55 honestly. 55.
I think what you've written is wrong. The number of who can call in by pen. The ending should be 2158. You've written 21581.
It should be 2158.
It's stop at 8 only, isn't it? Then the present applicant is Zo Sang Kim, is
So
it?
Sang Kim. It ends with 1842.
1842. And who is this? What is his name? Starts with H. You don't have a second copy with you?
No, my lord, I have only the copy because it's a huge one, my lord. Actually, it's 1A to 1E. That is one page.
The thing is that this name, I can't read. It begins with H. What is it? Half daily?
Sina.
Half daily? How daily or what? China.
How they Sina. This is the other co-accused.
Okay, how they China.
Yes.
Okay. Why have you given in this two booklets?
The other one
Yeah.
is the CDR of Zosang Kimi, and the other one is Kup Kankwals, both of them. So
Kup
it's-
Kankwal, Zo Sankimi, and how they chin. But both are Zo Sankimi. Here's also Zo Sankimi. He's also here.
Actually, Kup Kankwals and Zosang Kimi, they contacted each other. So
Okay.
those two are the CDR.
When was she arrested? The dates given in this CDR, how is it to be read? Is it the Indian way of reading it or the American way of reading it? Like the date comes first or the month comes first? What is the date of arrest?
9/11.
9/11.
9/11/2022, and yes,
9/11. Date of arrest.
date of arrest.
Okay, so this is the Indian way. The calls are on 8/11.
Yes.
I think all the calls are on 8/11. This bail application is for the first time or this is the second round? First time.
This is the first time.
First time in this honorable court, my lord. It was rejected by the learned trial court.
Okay. So anything you would like to submit?
Yes, my lord. Even though, despite the CDR which is produced by the learned PP, my lord, I have compiled the citations which I want to rely upon, my lord. The authorities.
What are those?
These are the first one, my lord. I have marked the page number also, my lord. The first list is 2022 volume 12 SCC 633. Para 12. This is regarding CDR details. It says that CDR details should be examined at the time of trial, and it has nothing to do with the granting of bail, to deny bail, my lord. That is what it says. And I have list of 9 citations, Your Lordship, which would have my case.
Just a minute, okay. Para 12, you say?
Yes. It starts from Para 12 is at page 7, my lord.
Just read.
My lord, yes. Para 12. It has been held in clear terms in Tofan Singh versus State of Tamil Nadu that a confessional statement recorded under Section 67 of NDNPS Act will remain inadmissible in the trial of an offence under NDNPS Act. In the teeth of the aforesaid decision, the arrest made by the petitioner NCB on the basis of the confession or voluntary statements of the respondents or the co-accused under Section 67 of NDNPS Act cannot form the basis for overturning the impugned orders, releasing them on bail. The CDR details of some of the accused or the allegations of tampering of evidence on the part of one of the respondents is an aspect that will be examined at the stage of trial. For the aforesaid reason, this court is not inclined to interfere in the order dated so and so, number arising out of diary numbers so and so, respectively. The impugned orders are accordingly upheld, and special leave petitions filed by the petitioner NCB seeking cancellation of bail granted to the respective respondents are dismissed as meritless. My lord, this is also clearly applicable in the present case because the only allegation made against me is that due to the statement made by Kup Kankwala, the co-accused Kup Kankwala, and that call, the thrice, the 3 times call, that is one received by me 2 times, and that the calling back of Kup Kankwala, that is as per the CDR.
Recovery was made from whom?
Recovery made from Kup Kankwala only.
Kup
my lord.
Kankwal.
No recovery was made from me. So I was taken from my residence, saying that on the basis of Kup Kankwala's statement, that I was arrested, my lord. So it is well applicable. Nothing was seized from me.
How much was recovered?
It is 1.747 kg.
Sorry?
1.747 kg of suspected heroin.
747.
747. 1.747 kg.
Suspected heroin.
Heroin, my lord. the main, so to say, my lord, the main two accused persons are Hau De China and Kuk Khan Kuala.
When was this? From which place?
From
Which place? Lunglei?
my lord, Lunglei, my lord, Tlong Road. Tlong to Lunglei Road.
On which date?
They were arrested on 9/11/2022. The operation was conducted on the previous date, 8/11.
The recovery and arrest was done on 9/11.
9/11, my lord. Yes.
Operation happened on 8/11.
8/11.
What kind of operation?
Operation, it was conducted by the DSB, staff of DSB Lunglei district.
Okay. Then the next
Then
citation?
the next citation is, my lord, that is
Page
regarding, this is the Delhi High Court, my lord. I have cited this due to the reason that it says that no recovery was made, no money transaction was there. So on that ground, bail was granted. Here also it was allegation was that I am the one who has to purchase.
So before you purchased, it was recovered.
Yes, that is the allegation, my lord. And the third citation also, my lord. It is
No, just a minute. What is the
Sorry.
relevant para? 9
Para-
to 10.
No, my lord. Para 22 and 23.
Sorry, 22, 23. Yes. 22, 23.
It is at page 18.
You have a copy?
Yes, my lord.
Just read.
Para 22. In the present case, there is no narcotic substance or psychotropic substance recovered from the applicant or from his premises. There is no recovery. The disclosure statement made by the applicant, according to me, cannot be read against the applicant. The fact that the anticipatory bail moved by Amarjit Singh Sandhu has been rejected by this court, or that Amarjit Singh Sandhu is absconding, cannot be a ground to deny bail to the present applicant. In the present case, there are no monetary transactions, bank statements or finances which shows the sale or purchase of prohibited narcotic substance or psychotropic substance between the applicant, Syed Javed Hussain and or Amarjit Singh Sandhu, except the statement of Syed Javed Hussain, who stated that he used to purchase contraband in Delhi through the applicant. There is nothing which shows the sale and purchase of prohibited narcotic substance or psychotropic substance between the applicant, Syed Javed Hussain and Amarjit Singh Sandhu.
Okay, I think that should do.
Yes. it will do.
Then next one.
The next one is, it is also regarding this, also Delhi High Court, my lord. It is regarding CDR. Again, that cannot be ground to deny bail. And relevant para is 24 and 25. It may not be necessary to read, my lord, or if your lordship wants me to.
Which is that para page?
Page 24 and 25. Page 26, my lord.
Paragraph 24 and 25.
24 and 25 will be relevant. In the absence of any other incriminating material, my lord, CDR details cannot be ground. Para 25 is very relevant, my lord. It says that in the absence of other any incriminating material, CDR details cannot be ground to deny the bail.
Then the next one.
My lord, the next one is passed by this honorable court at the principal bench. It starts from page 29. Para 15, 16, 18, 19, 20 and 24 will be relevant. This is regarding the accused who was arrested only on the basis of the statement of the co-accused, my lord. And this honorable court had made an observation that while releasing on bail, that rigors of section 37 may not be applicable in such case, my lord. May not be applicable in the sense that, my lord, it may be, despite rigors of section 37, bail was granted. Para 18, page 40 may be relevant, my lord.
Para 18.
Para 18. Shall I read, my lord?
Yes, read.
In the backdrop of the above, let the preceding paragraphs mention about that section 37. It was exhaustively appreciated, my lord. In the backdrop of the above, let this court take into consideration the materials before this court. As already observed herein above, the petitioner was implicated and apprehended only on the basis of the statement made by Srimati Lalpi and Moi, the co-accused, during interrogation. During the search and seizure so carried out at the residence of the petitioner, there were no offending or material substance found in terms of the Act of 1985. What was seized were 3 mobile handsets and an amount of rupees 35,600. It is also very similar to the present case. Only mobile phone was also seized in this present cited case, my lord, and nothing was seized from her. And
What was this? This is a bail application.
Yes, bail application, my lord.
And paragraph?
I have just read paragraph 18 and 20. The reason why I'm saying 20 also is that, my lord, it has referred to Tofan Singh versus Tamil Nadu, which I've just read out in the earlier cited ruling, my lord.
Are you sure it was a bail application?
Yes, my
Where
lord.
was the beginning part?
Yes, page 29, my lord. Dimsian name alias Priscilla. Bail application number 2090 of 2022.
So the opinion was rendered that there's reasonable grounds that he might be acquitted.
Yes, my lord.
She might be acquitted. So
Yes.
that was the thing. Then
Another
next-
one is starting from page 45, my lord. There is the order passed by this honorable court at principal bench in bail application number 862 of 2021. It mainly says about the fact that no seizure from the possession of the accused. That could be the ground, which is similar to the.
This is again on the same point.
Yes, my lord, same point.
No seizure,
Exactly.
no transaction,
Correct,
no
my lord.
recovery.
Correct.
So same point.
Same point.
Then
And my
Anything
citations, serial number 6 to 9, these citations mainly says about the period of custody of the accused person. Here, serial number 6, 1 year and 11 months in custody. And serial number 7, this is 3.5 years in custody, but several witnesses still to be examined. And serial number 8 also, out of 10 witnesses, only 4 witnesses had been examined. And some other witnesses are still to be examined. And serial number 9 is 1 year and 7 months in custody, my lord. Due to these grounds, they had been released. And in my present case, PW 12, 15, 16, 17, 18, 19 and 20 are still to be examined, my lord.
how many witnesses?
20 witnesses are there.
How many to be examined? Who are they?
12. There is the witness.
12 remaining.
12, 1, 2, 3, 4, 5, 6, 7. 7 witnesses are still remaining, my lord.
Who are they?
They are the forensic expert,
No, witness number?
witness 12, 15, 16, 17, 18, 19 and 20. My humble prayer is that, my lord, on these grounds, I may kindly be released on bail at this stage.
So 13 out of 20 have been examined.
Yes, my lord.
Ms. Linda, anything?
My lord, we have a very speedy trial. Out of 20 witnesses, we have already examined 13.
Okay.
And the involvement, my lord, as has been pointed out in the charge sheet, is proved that the essay was recovered from the co-accused and it was supposed to be delivered. And this has been proved by the CDR, my lord, the call details report. And there has been several WhatsApp messages. So on the basis of that, my lord, the rigors of 37 will also apply to the present applicant. And the bail application may be rejected at this stage.
Okay. We'll consider and pass necessary orders.
My lord.
All right.
Much obliged.
Daily list for admission, item number 2.
This will be disposed.
My lord, in item 2, I still have not received Paraguay's comments. I have contacted the department today, this morning, and they have informed me that Paraguay's comments is already prepared and it has been put up for approval. And it has not returned yet.
My lord, I have no objection if she's permitted, granted further time.
It's more than a year, my lord. I've pushed them. I've also sent a
2
reminder.
weeks? 2 weeks? How much time?
2 weeks, my lord.
Okay, as paid for by Ms. Linda L. Fumble, learned additional AG, appearing for the state respondents. Further 2 weeks' time is granted
My lord.
to obtain instructions and to file counter affidavit. Stop Mr. Elish Yanfima, Learned Senior Counsel, assisted by Ms. Lalwat Fedi, appears for the petitioners.
Item number 3.
My lord, I'm seeking time to submit the affidavit in opposition, my lord.
Yes, how many respondents? You're for which
I'm
respondent?
for respondent number 1 and 2, my lord.
There's one more?
I'm yet,
There are 3 respondents, it seems.
yes, my lord. Third one is the government, my lord.
Who will be appearing? No, there are 4 respondents.
The fourth one would be the present CEO, my lord.
The respondent number 2 retired and respondent number 4 was impleted as he's the new CEO, Your Worship. So notice was issued on 5th of September.
So 1, 2, and 4 are relevant, is it?
Yes.
You're for 1 and 2.
Right now, my lord, I'm for 1 and 2. Even 4 also will be representing, my lord. I'm yet to file Bakalan Nama, my lord.
Okay. Your good name?
Lalruat Pesalo.
Mr. Lalwat Silo, Learned Counsel, submits that he may be given further how much time?
Maybe, my lord, 2 weeks if possible.
Further 2 weeks' time to file the show cause reply on behalf of respondent numbers 1 and 2. To stop, he further submits that he'll be appearing on behalf of respondent number 4 as well, and for which he prays for 2 weeks' time to file his power as well as the show cause reply. Praise aloud.
Yes, my lord.
List again after 2 weeks.
Similar order in item 4.
Show cause be filed in the meantime. The parties are also similar?
Same, my lord.
Okay, similar order, item 4.
Item number 5.
Applies, my lord.
Item 5, Your Lordship, I seek Your Lordship's indulgence in this matter. Uh, notice of notice upon respondents 5 and 6 was allowed to be taken through Dasti. And Your Lordship, due to their changing of address, we could not locate them till date. So if I may be given another 2 weeks' time to serve notice, Dasti service on respondents 5 and 6.
Okay. Meanwhile, anything to be done?
No, Your Lordship. If the records have come, Your Lordship, paper book will be required.
We'll share there. Mr. A.R. Malhotra, Learned Counsel, for the appellant submits that due to change of address, the address of the respondent number 5 and 6 could not be ascertained to serve notice by way of Dasti as permitted by this court. So he therefore submits that he may be granted further 2 weeks' time to serve notice to them by Dasti. Stop. Next para. It is also seen that the LCR has arrived. And therefore, registry shall prepare the paper book at the cost of the appellant. List the matter again after
2 weeks.
2 weeks. Ms. Linda L. Fumble, Learned Additional AG, appears for the state respondents.
I haven't got it.
Item number 6.
This is a jail appeal, is it?
Yes, my lord.
Convicted under Five, 6, 24. He's right. This is an appeal from jail filed by the convict / appellant against the judgment and order dated 5/6/2024 passed by the Court of Additional District and Session Judge Aizawl in SC number 103 of 2023. Convicting the appellant under sections 307/326 IPC. Put slash again before IPC. There'll be 3 sections, okay? 307/326/324 IPC. And thereafter sentencing the appellant to undergo rigorous imprisonment for 8 years for conviction under section 307 IPC and for 7 years for conviction under 326 IPC, and for 2 years for conviction under 324 IPC. White sentence order dated 12/6/2024. Stop. The learned trial court has directed that the sentences shall run concurrently. Can you just add one more thing in that one by one? The 30 conviction for 8 years. I said 8 years, huh? After 8 years, you just add with fine of rupees 5,000 and default clause. Then after that 7 years, you write with fine of rupees 10,000 and default clause. Then after that 2 years, you write with fine of rupees 1,000 with default clause. Next para, let the appeal be admitted. Call for the LCR. Issue notice to the state. Ms. Linda L. Fumble, learned public prosecutor, accepts notice, and therefore no formal notice will be required. Stop registry to furnish the relevant papers to the learned public prosecutor. List the matter again on receipt of the LCR.
Item number 7.
My lord, for the respondent number 4, I seek another 3 weeks time for obtaining instruction and for filing affidavit.
Your Lordship, on behalf of the state respondent, we have already filed our affidavit in opposition.
Your good name?
Fabiola Rinomi.
Sorry?
Fabiola Rinomi.
Ms. Fabi Lorinomi, learned counsel, appears for the petitioner, and Ms. Lalnunlui, learned government advocate, appears for the state respondents and submits that the respondent numbers 1, 2, and 3, whom she represents, have already filed their counter affidavit. So Ms. Zairem Sankui, learned CGC, who appears for the respondent numbers.
4.
Respondent number 4 submits that she may be given further 3 weeks' time to obtain instructions and to file counter affidavit. In prayers aloud. This is the matter again. After 3 weeks, petitioner may file rejoinder affidavit to the affidavit of opposition filed by the respondent numbers 1, 2, and 3. In the meantime, if so advised.
Which obliged, Your Lordship.
Unlisted matter AB 12 of 2024.
May I please, Lordship? This is a petition bail application, Lordship. FIR is page 12, Lordship. It's a long FIR, Lordship. May I read, Lordship?
Just a minute. See, they have again included the IA and the bail application. Okay. Yes, you were saying?
This is a previous bail, Lordship. FIR is page 12, Lordship. It's a long FIR, Lordship. May I read the FIR? In December 2021, Thauma of Guwahati contact number so-and-so informed me that NHIDCL is looking for Mizoram road construction 2-lane, Dulti to Champai Road. He said that it was the work of Central Minister Nitin Gadkari's son and Rajesh Kumar Balaji Enterprise, contact number so-and-so, and he also is entitled to be part of work along with them. The Rajesh Kumar also traveled to Delhi to meet us. Then we agreed to work together. Rupees 65 lakh, including my sister's so-and-so amount, rupees 10 lakh, was deposited in Thauma's account. Later, NHIDCL cancelled the Dulit Champai Road. After that, Thauma and Rajesh Kumar went to Aizawl. We met at Thauma's office. So-and-so, Rajesh Kumar invited us to become One Life member, Lordship. He said that he would be able to participate in One Life project, rupees 200 crore, Lordship. Delhi Police Housing Project at Dhirpur, which requires rupees 6 crore for EPC, 1.5 crore for the project, of which 3 crores will be earned. Then an agreement was signed and the money rupees 1.5 crore was transferred to Rajesh Kumar's account in January 2022. Received phone numbers included. As promised, I was liable to be paid the capital and the interest worth rupees 3 crores on or before March 2022. Then, as he promised, he did not give us back the money. In November 2022, rupees 33 lakh was paid 3 times to my bank account, Lordship. Despite of requesting multiple times to return the money, there was no positive response. Instead, they continued to offer justification by making excuses. He also claimed to return me the money and gave 2 bounce check, 100 plus 200 crore, Lordship. Rajesh Kumar and Thauma are the ones who have deceived me with intention. I request you to take action so and so. This is the FIR, Lordship.
Where is your name? In the FIR?
Thauma is my name, Lordship.
Thauma.
My full name is Lalro Thauma Thek, Lordship. Lordship, kindly turn to the page.
FIR,
Page 18, Lordship.
FIR is dated
31/1/2024, Lordship.
31. Where do you find the date?
At page 14, Lordship. Page 14. Top right. Date 31/1/24. Lordship, may kindly come to page 18, Lordship. A 41A notice was served upon me and I appeared on 4/7/24, Lordship.
Yes.
Again on 17/7, I appeared again second time, Lordship. I was called by mobile phone by IO and I was asked to produce the vehicle which was bought by me. Page 19, Lordship.
What is page 18?
Page 18 is the 41A CRPC notice, Lordship.
Notice to appear before the police?
Yes, Lordship. And I appeared on 4/7/24, Lordship. At below, the IO has signed on my appearance, Lordship. At below, appeared on 4/7, signature of the IO, Lordship. Now, Lordship, may kindly turn to page 19, Lordship. Again, I was called by mobile phone by the IO to produce the vehicle which was purchased by the said fund, Lordship. And I appeared and handed over the vehicle to the IO, Lordship. Third para, Lordship, at below. May I read, Lordship?
Yes.
On 17/7/24, in compliance of his disclosure statement, accused Lalro Thaumathek, this is me, Lordship, the present petitioner, produced one vehicle purchased with fund out of deposit made by the complainant. Note below, which was seized in the presence of witness. I himself produced the vehicle, Lordship, to the IO, Lordship. After producing the vehicle, the IO let me go, Lordship. Now, Lordship, kindly turn to page 20, Lordship. Again, one more notice was served upon me, Lordship. Dated 19/8/24 to be appeared before IO on 22, Lordship. And Lordship, on apprehension of this notice, Lordship, the present application has been filed, Lordship. I had already cooperated with the investigation, Lordship.
No, 22 August was last month.
22/8/24, I have been told to appear before 22/8. And notice was on 19/8.
Correct. So did you appear?
No, Lordship. His apprehension that he may be arrested, Lordship. For this reason, his application has been filed, Lordship. He already appeared 2 times, Lordship. And I was allowed.
No, if he's appeared for twice, 2 times, why has he failed? And if you are to be arrested, he should have been arrested by now.
So I have already appeared for 2 times, Lordship.
Now understand, you have filed this anticipatory bail application because you anticipate that you will be arrested. When the police has summoned you on to appear on 22nd of August, you have not appeared.
I was in medical.
You have not appeared. So the police should have come and arrested you. They have not arrested you till now. Where is your apprehension?
Apprehension is the Lordship. Petitioner is on. If he appears before the IO, he may be arrested. This is the apprehension, Lordship. He already appeared, Lordship. And Lordship, kindly may page 21, Lordship. This is my medical document, Lordship. I was unable to appear before the IO on the medical. I was in medical care, Lordship. From 13.8 to 22.8, Lordship.
Okay, what is the nature of the allegation otherwise?
Allegation is Lordship 420, 403 of IPC, read with section 138 of NI Act, Lordship. 403 and 138 is bailable offense, Lordship. Only 420 is non-bailable. And matter is purely in civilian nature, Lordship. Everything will be proved on documentary evidence, Lordship. Police can't prove the said fraud had been done or not, Lordship. The main accused is already arrested, Lordship. As per my instruction, Lordship, he is behind the bar, Lordship. .403 is 2 years punishment and 138 is 2 years punishment, Lordship. Both are bailable offence. I have already cooperated, Lordship. I am the local person of Mizoram, Lordship. Kindly allow me to go on period bail, Lordship.
Have you served copy to the other side?
Yes, Lordship.
Miss Linda, you are here.
2 copies was served, Lordship, yesterday.
We have been served, but we didn't know that it will be taken up today, my lord. They have
You
not
should have
informed us.
you should have informed the other side that we are mentioning this case.
Lordship, actually, I am from Guwahati, Lordship.
You may be from anywhere, Mr. Counsel.
Process-
This is the minimum courtesy that you have to show to your colleagues. That we are moving the case today, please be there. I'll be moving unlisted motion. I'm asking for the court to move. If it's permitted, it will be moved. So that kind of, like intimation should be there. You keep that in mind.
Yes, Lordship.
You are a young lawyer, you see. Should always, because we cannot proceed without the public prosecutor.
Yes, Lordship.
Likewise, without you, the other side also cannot move. So we need the assistance of both parties. So you should make it conducive for the court to proceed by, because you have asked for unlisted, it has been listed as unlisted. Had it been listed already yesterday, then they have no excuse. But since it was unlisted, you should always do that, mention. All right, we'll issue notice at this stage. Huh? Your good name?
SK Chhatri, Lordship. Kindly protect me, Lordship. I already appeared on 2 times, Lordship. I'll cooperate with the investigation, Lordship.
Where is your name?
I filed the Wakalatnama, Lordship. My name is not appeared in the cause list.
Pinkish Hill is there.
This is my sister, Lord.
What is your name?
SK Chhatri.
SK Chetri. Please write, heard Mr. SK Chetri, learned counsel for the applicant, who submits that by filing this application under, is the sections correct?
482 BNSS.
Let's see. In the old act, it was an inherent power, is it? 482? Under CRPC?
438.
No, not anticipatory bail. I'm talking about the inherent power of the court. No, that's right. It's inherent power of the court. Summons, by filing this application under section 482 of the BNSS, the applicant prays for grant of anticipatory bail since he apprehends that he may be arrested in connection with the FIR lodged on 31/1/2024 by the complainant before the officer in charge, comma, crime and economic offences, police station, Aizawl, Mizoram. We'll stop the. No, you cancel that. A case under section 420/403 IPC, as well as under section 138 of the Negotiable Instruments Act 1881 was registered and being investigated into. Stop. The Learned Counsel submits that pursuant to the notice received by the applicant under section 41 capital A of CRPC from the investigating officer comma, the applicant has appeared before the said authority on 4/7/2024 and on 17/7/2024. Stop that. Whose vehicle is this?
Vehicle is in my name, Lordship.
The investigating officer has also seized vehicle of the vehicle registered in the name of the applicant bearing registration number AS01 EY3207 bracket Kia Seltos, KIA, separately Seltos, SELTOS. Full stop. The Learned Counsel submits that despite cooperating with the investigation, the applicant has been summoned again. The applicant was summoned again by the case IO on 22/8/2024. After that, you just add, was summoned after that to appear again on so and so, 22/8/2024. But the applicant, apprehending that he will be arrested by the police, did not appear on the said date. Most of the Learned Counsel submits that the applicant is innocent and has not committed any crime as alleged by the complainant. and therefore, in the event of his arrest, he will suffer irreparable injury and loss. Stop. He therefore summons that the applicant may be granted anticipatory bail, and that the applicant undertakes to fully cooperate with the investigation. Next para, in view of above, issue notice to the state.
My lord, if it's under NI Act, they have a special public prosecutor, separate one.
Okay. Who, Mr. Zoram Sana?
Mr. Zoram Sana, C. Zoram Sana.
Okay. You find out, Mr. Zoram Sana, what did I say? Returnable by October 17th. Okay. You're coming from Guwahati?
Yes, Lordship.
When can you come? Again?
Again, Lordship, on 24 or 25, Lordship. We have to plan our travel, Lordship, that's why.
Returnable by 24? 24/10/2024. Stop. The applicant shall serve notice to Mr. C. Zoram Chana, Learned Special Public Prosecutor under the NI Act, and after obtaining acknowledged from him, submit the same before the registry as proof of service. Stop. The Learned Special Public Prosecutor shall produce the case diary on the next date fixed. Next para, having regard to the projection made and as an ad interim measure, it is hereby directed that in the event of his arrest, the applicant will be released on furnishing bail bond of rupees 25,000 with one surety of the like amount to the satisfaction of the arresting authority. Stop. The ad interim bail is also granted subject to the applicant fully cooperating with the ongoing investigation by ensuring his presence as and when he is required. Stop. The applicant shall also not leave the state of Mizoram without prior intimation to the case IO, mentioning the place of his travel. List the matter again on 24th. All right?
Deeply obliged. Deeply obliged.
You send that matter to me, that bail application, and plus that criminal appeal also.